Executive Officer of Taxi Council Queensland.
Thank you. And would you like to make a short opening statement?
Yes, I'd just like to thank the Chair and the Committee for giving Taxi Council the opportunity to come and provide evidence today. I'm very aware of the size of the number of submissions that you guys received and the amount of work that you have to get through between this and other committees, so I'll keep my opening statements very brief.
Thank you.
First and foremost, I'd like to actually acknowledge the fact that there's two very distinct things occurring in the taxi industry, and contrary to any other evidence you may hear during the course of this process, I'd like to make sure that you keep in mind that this is very much about the bill, as Mr Hart actually stated before, and there is also a review going on. That review was set down for a time frame in 2008 by the then Minister Rachel Nolan, and whatever that review transpires in that review is not to be confused with this issue that is here. The issue before us is about the enforcement and penalties that are associated with the operation of illegal taxis, and the fact that the current penalties and enforcement regimes were proving insufficient. I think it's worth noting that just a couple of years ago, through some industry liaison groups that were run by the Department of Transport and Main Roads, there was a group of people who were tasked with going through websites such as Gumtree, Craigslist and other classified type websites, seeking out the operation of illegal taxis and writing to them and offering advice in terms of shutting down because they're operating services without a taxi service licence. And in actual fact, just 6 months before that, there was an exclusive done by a 10 News investigation team on the Korean community offering illegal taxi services, and the government brought the full weight of their compliance activity to bear on that. Fast forward to now, and again, notwithstanding what may be in any of the other submissions, the actual fact is nothing has changed as far as the legislation goes. The only thing that appears to have changed is that the department have become overwhelmed in terms of being able to compliance this activity. Previously, financial penalties or the threat of financial penalties was sufficient to modify people's behaviour to not offer those services, even though they might not have been aware that those services were illegal. There's a lot of discussion around the fact that the legislation doesn't effectively or didn't effectively anticipate the current technology, I suppose. In actual fact, it absolutely anticipated that, and I don't need to go into that. What it didn't anticipate, however, was a company whose modus operandi was to operate outside of the regulation and to just simply treat as an operational cost any penalties that are born of that. I must state, as I did last time I appeared before the committee, it's not just one company. That one company happens to be much more bold and brash than others and much better financed. But as recent as this week, we have small illegal taxi operators advertising back on the web in central Queensland offering to do illegal taxi services. It's not about a particular company. It's not about commercially penalising a new business model or however it may be described. It really is simply about the rule of law and ensuring that the outcomes expected by the Queensland community for taxi services remains unchallenged until such time as a review may come back and give the government something to consider as far as reforms. But that's not what this is about. I'm happy to take questions.
Thank you. Just go back to the review to start off with. Might help us to get a good understanding of that, because my understanding was there's a review that's coming up in 2 years' time, is it, or next year, or
no,
the proper review that you guys had in place, that where you would have a review with the government about the services and that all provided?
That was set down in 2008 when they when the
it's supposed to be every 4 years or 5 years or something after that?
Well, it was set down in 2008 when the government adopted the 2010 to 2015 Queensland Taxi Strategic Plan.
That's right, yes.
So that's the plan. Having said that, I anticipated, to be honest, I anticipated the former government to actually announce a review in it with sufficient lead time so that when we got to the 31st of December this year, we weren't left with a gaping hole in terms of the seamless sort of movement to a new strategy. But that didn't occur for any number of reasons.
Yep. Well, given that this issue has been developing for a while, the Uber issue. I had an understanding that the Taxi Council had spoken with government and they were happy to wait until that review process came to a position where the review commenced. What I can't understand is why would the Taxi Council, if that is true, why would the Taxi Council say that they don't really want to deal with that until such time as that review comes around?
Well, firstly, I can refute those comments. That's not the case at all. What we said was we understand that there are regulatory reforms that are coming up in the review and the review of the strategic plan. Having said that, if there is any regulatory reform that's going to affect the structure of the industry, that needs to take time. As far as this issue, we never said that we wanted to see the government suspend any of the existing regulations pending the outcome of that review. What we said is that enforcement needs to be carried out on the streets now as it stands, and at no point on the public record or in private have I said that we're happy to see this issue dealt with entirely during that process.
Okay. Could you give me your version of an illegal taxi service?
So an illegal taxi service is any service that offers either street hail, rank and hail work, or is available on demand through some sort of booking system to take someone somewhere from point A to point B for commercial hire.
Michael, just a couple of questions.
Yeah, Ben, as I said to the previous submitter, we're here to look at this particular issue and demerit points, but you've proposed a few amendments in your submission. Can you step us through the reasoning behind that?
Sure. The amendments that we've proposed is to the Transport Operation Road Use Management Act. And in one of the schedules of that Act, and just for everyone's, I'll refer to it as tow run, for everyone's information, that's the enabling piece of legislation for the Queensland Police Force in the road policing command activities that they carry out throughout the state. And that covers any number of things from, driving under the influence to use of mobile phones and other infringements on the roads. The tow run currently requires the police to actually carry out all of the activities specified in what is referred to as Transport Acts. And currently in the schedule to that Act, the Transport Operation Passenger Transport Act is not referred to or not identified as a specific Transport Act. We're seeking an amendment to that particular schedule to include TOPTA, which includes the licensing of taxis. And the reason why is in the absence, that is one area where the Queensland Police Service, who we believe should have been involved by now, have been able to successfully argue the case that there is no specific legislative pointer that requires them to carry this work out, whereas that schedule does refer to the Land Transport Act, which deals with yellow lines and parking or indicating too close to an intersection and the road rules. It does refer to other sections of tow runs and a couple of other acts dealing with ferries and that sort of thing.
Okay, and your submission also, you put forward the view that Uber's not paying GST and that they possibly should. Can you tell us about that? So
under the GST legislation, during the process of negotiating it, one of the things that the government sought to do was to address what they considered black holes or remnants of the cash economy. And taxis were considered to be one of the last bastions of the cash economy. So in bringing the legislation about, they provided a $75,000 exemption for all small businesses with the exception of taxi drivers, because they believed that the taxi drivers would be seeking, or the taxi industry sought to not pay taxes. So they tightened the legislation. They said if you want to work in the taxi industry as a driver, you have to register for GST from the first dollar that you earn. So no exemption actually exists. If, as well as that, you carry out other businesses, those other businesses you must declare and apply GST to every dollar earned on that as well. What we're saying is, and we agree with the tax office ruling on ride sourcing, which is effectively if you're offering a vehicle for hire, regardless of how you get to that vehicle, that's what we're going to call a taxi service. It's our definition, not necessarily a position defined by different state governments. And I mean, as many of you would know, tax law often follows its own path and that can be set as precedent regardless of what different states and territories may choose to do. This is one of those instances, and they've said that this is how we're going to apply it. GST should be applied. Currently, from the 1st of July, there's a ruling, 1st of August this year, there's a ruling that actually requires all Uber drivers to be registered and apply GST, but Uber has challenged that in the federal court. And what's occurring as a result of that is you've got people who are offering taxi services who are not paying GST. Notwithstanding what the court outcome is, ATO rulings have the full force of federal law until such time as the court overturns it, which makes it quite a different policy creature to what other policy areas in state and federal government is. The tax office actually has a lot more power than many other agencies.
Yeah, Benjamin. Just, I note what you said there in regards to the amendments in regards to strengthening, the more or less police involvement. Do you see that the department is more or less too relaxed in regards to the illegal taxi driving as Uber as in general?
Look, to be honest with you, I think the department under the former minister and this minister up until July this year were doing their job and doing it well. What the legislation, as I said earlier, could not anticipate was a business model that actively sought to subvert compliance activity. That actually, a business, if it's genuinely believing that it's doing the right thing, then bring along your enforcement, I'll challenge it in court and I'll follow a normal court, in the same time frame. Now, how that translates within a fleet of taxis is it means that you have to provide enough wheelchair accessible services so that when someone does order a vehicle, that they've got an equal chance of getting something in the same time frame. If you have too few, then you're in a position where you can't actually offer that service. In fact, if you only have one vehicle in a fleet, if it's occupied, you can't guarantee any level of service beyond that. Obviously, given the operating costs of such vehicles are substantially greater because of the modifications that they have to undertake, there's a question of commercial viability. So the fleet is continually trying to gauge what is the appropriate level. Is it 1 in 4 cars that we need to have? Is it 1 in 5? The Queensland taxi industry has approximated 1 in 5 across the state. And to put that in perspective, that's around 2 in 100 in New York City, which is considered to be one of the greatest markets of taxis. So we really are, providing a service 10 times the level of many other taxi industries that we may be compared to. The current services, as I understand it with Uber, is that they are sitting outside of the disability standards for accessible public transport. So notwithstanding what representations they might make about the sort of service that they are, there's actually no obligation to do so. And in the event that they don't provide such service, there's no recourse to an agency or anyone else. There is a possibility for an anti-discrimination course to be brought to bear, but I think the sheer size and wealth of Uber as an organisation would be far too intimidating for the average punter to try and make a representation to protect themselves, because they'd fear being crushed by the court system and being bankrupted by a wealthy multinational.
Oh, I'm just listening.
You got any more questions, Shane?
Just in regards to it was mentioned there previously about it's a criminal offence in other countries, and I don't think the previous taxi driver referred to want to see this happening, but is that the feeling of the taxi industry towards the Uber drivers who are driving illegal taxis?
Look, as an industry, I can say that we certainly feel frustration. There's a lot of, we're not understanding how this is happening. But look, I think you'd find that within the industry, if you break it down to the individual owners, operators and drivers, they don't bear any particular malice towards people. If someone's been deceived into carrying out an illegal activity or engaging in criminal activity, if it's defined that way, I don't think that they would be seeking to see that person thrashed because they were deceived into a situation that compromised them and the community. What we just want to see is legislation that is robust, that delivers the things it needs to deliver, and it's done on a level playing field. we're not here to discuss, this bill isn't about discussing the philosophical structure of the industry. A whole review has been set up to do that, and it's resourced, and we will collaborate and contribute to that. This is really about the existing laws and saying, well, our penalty regime has failed. It needs to be upheld. We would not like to see suspension of the existing penalties within the industry, much less to anyone who may be operating on the fringes of the industry. So I would say that from what I understand, the industry bears no particular malice, and we don't want to see people charged with criminal charges just because. We just want to see them being educated. A first and final warning with a fine would maybe be appropriate, but I certainly think that there needs to be demerits associated with it, partly because it's not the individual who's bearing the cost of those fines. That's what makes this fundamentally different. There's been a situation a few years ago in Toowoomba, it was reported in the papers, where at graduation time of year, operators of restored veteran vehicles were offering for hire those vehicles for young graduates to go to their high school graduation, that sort of thing. And the same for the universities. Now, they were operating outside of all of the legal frameworks, and the Transport and Main Roads Department wrote to them and explained the situation. There was community outrage, and these people went to the papers, but in actual fact, Transport stood their dig and they just said, look, happy for you to lobby to have some sort of suspension of the rules in future, but at this point in time, they're the rules, they're there for very good reasons, and we're prepared to argue that case. That's on an individual basis, and whether people like it or not, Queenslanders are happy to accept the rule of law. The dynamics completely change when you've got someone who has operated brashly internationally and stood up to the might of governments and has a huge arsenal behind them. So that changes the whole dynamic. That's why demerits are necessary, because the individual might be deceived, they come in, they carry it out. The individual in most circumstances could be told you're doing the wrong thing and a penalty will apply, and that will stop them. But in this case, the individual is emboldened because they've got a machine behind them that's saying, don't worry about it, carry on. I'll take care of that for you. So we need to break the nexus between the activity that's being carried out by the organisation that's creating this deception and prepared to finance the ongoing activity for its own profit, and the individual. We need to now make the individual, this is all about actually making the individual responsible to their actions.
Benjamin, I'll ask that you accept my apology if I get the language wrong, because I'm not an accountant. But I'm just a little bit interested in the money that a taxi owner would take as part of collecting fares, paying GST and all that sort of thing. Would you have any understanding of what the difference between what you guys have got to go through, or the taxi operators have got to go through, up against what Uber drivers would have to go through with regard to declaring monies that they might take and pay out?
Sure.
Do you understand that? Well,
just
well,
on a fair-by-fair basis?
Yep.
Like on an individual fare?
Well, I want to know if you guys are really, you're in a position where you have to pay.
That's exactly right.
I want to know if the other group, Uber, are in a situation where we actually know how much those people are taking and where's it going to, who's paying GST, who's paying taxation.
Yeah. Okay, so this actually comes back to, again, with any licensing regime, part of the reason the government licenses or creates a licence is so that it can regulate other aspects of the operation of that business. And one of the things that's regulated within that is the taximeter. So taximeters now are very, very sophisticated pieces of equipment that go back and send a lot of information back to data dispatch systems, and those dispatch systems capture a whole heap of things. They're hooked up with toll systems so that there's a certain amount of revenue that is collected when someone decides to go through a toll. There's GST applied to that. If someone chooses to pay my merchant, all merchant services, contrary to popular belief, third-party merchants who are suppliers of merchant services to the industry. They're not part of the industry. They don't direct policy within the industry. So any additional charges that are attributable to the fare, they're collected as well. the meter issues an invoice, and this came about as changes in 2013 in collaboration with Transport and Main Roads to tighten up the level of disclosure that was available on receipts for each of the fares. There's now a requirement to split out all of those different items. That's available through the meter. It goes back through the operator software. It goes through the dispatch software. All of that information is auditable, and all of that information under tax law would be disclosable to the tax office. I think it's worth noting, in addition to that though, that anything up to 30% of any given fare is actually revenue collection for a third party. And because those charges are added on and charged at the point of sale, we often wear the bad press that comes with being the tax collector of a third party. They get the benefit of it, and we wear the bad press. It's not a bad business model if you're a third party using taxis to collect your revenue on your behalf. Those things are quite distinct from a platform that does ostensibly all the same things. The instrument that is the mobile phone, and no matter how Uber wants to try and paint it, it's operating as a meter as defined by Queensland law. I won't speak to the rest of the world or the rest of the nation. I'm unaware of what level of disclosure and breakdown that is. Because it's an offshore company and the transactions are processed offshore, I'm unaware what level of disclosure that you could reasonably accept. The only thing I can talk to is a commentary that came out of the Standing Committee on Economics held by the Senate recently, where at best you could say that the companies who were asked to attend just obfuscated everything that's going on. There were no clear answers coming out. There are governments around the world who have ordered with substantial fines to be paid to deliver up certain information, because policy is only going to be as good as the information that you can base it on. There's no evidence that you're going to get that information. So what I can say is what we give you is very detailed, it's auditable, and we're not trying to hide anything from anyone. I'm certain that there may have been an element of people in the industry who subsequently left when GST came in because they weren't happy with that level of disclosure, but that's long since gone.
So okay. I'll form my own conclusions on that.
It's a long answer basically to say,
no, that's
I don't know what you can get out of them, and I don't know how to translate.
One more question.
I'll just pull you back to the bill, Ben, and the demerit points. Your submission talks about the rule of law, and you already expressed that you maybe think the rule of law has not been applied sufficiently at the minute, and from the evidence that we've heard before, I think it has slowed down. But if the department said to us that they were having trouble catching people, so how is increasing the demerit points, if we can't catch them, how is increasing the demerit points going to help? I just want to be the devil's advocate for a second.
Sure. This is why we've recommended the amendment. The amendment would mean that you're applying police resources to actually capture them.
Right.
The demerits is to heighten the awareness of the individual of the gravity of the sort of thing that they're doing, the illegal activity they're doing. I know that in some of the submissions that they state that there's a general premise that demerits are applied for safety reasons. That's not necessarily the case, because demerits are equally applied for any number of different infringements, including failing to show an L plate or a green P plate, or these aren't safety issues per se, but demerits have been applied because penalties weren't considered sufficient. So demerits in and of themselves will not improve things. I'll give you that much. But demerits with appropriate enforcement will make the difference that is necessary, because even if you bring enforcement in without the demerits, where the individual has to bear the responsibility of their actions, then you can enforce it, and all you're going to do is create a new government revenue stream where millions of dollars are going to be poured in by a multinational. And I don't really think that's the purpose of the legislation. Government isn't there to be a revenue raiser. It's not a commercial venture. It's there to provide the frameworks for what we consider to be a well-regulated and well-governed society. Yeah. Queensland is that. I'd hate to see us go backwards.
Just clarify, we're talking about double demerit points in this case.
On the second offence, yes.
So are you saying that without the amendments, maybe this won't work?
It really comes down to compliance. Any piece of legislation will come down to compliance and an agency's ability to actually enforce the current legislation. Just one final point as far as double demerits go. Recently, the government sought to implement laws where mobile phones, use of the mobile phone attracted 3 demerit points, and second offence attracted double demerits. In this particular instance, the vast majority of illegal taxi work is done through interaction of a mobile phone. So I don't think that we're actually moving from, in terms of philosophy, we're not shifting very far from that piece of legislation. And that was a particular reason why the bill was put up on that basis, because you can't divorce the two.
Okay, thanks. Thanks, Benjamin. Time has expired.
Thank you very much.
No more further questions to yourself.